People of the State of Michigan versus Christopher Michael Drake, 2023431. Mr. Drake's appearing by video from the St. Joseph County Jail. Mr. George is his attorney, and Mr. Gabriel is the prosecutor. Mr. Drake was sentenced to the Department of Corrections back on January 29th. The Department of Corrections then notified the court of a potential error in the judgment of sentence that was entered. And so, having reviewed that and having seen this issue of clarification that needed to be made, I had Mr. Drake brought back, and we set this for a hearing with his attorney and Mr. Gabriel, the prosecutor. This case was resolved on December 28th, 2020, 2 days or 3 days before Mr. Marvin's term started, and it resolved around an offer that Mr. Drake plead no contest to one count of CSE in the second degree, dismiss everything else, and dismissed file 20-23432. Unfortunately, he was charged in that case as CSE in the second degree with a prior conviction as a second or subsequent offense, as also habitual fourth. And so when it came to sentencing, it's listed as a CSE second degree involving a person under 13 as a second offense, as was listed in the information. That was not mentioned at the time of his plea, when he entered his plea, and it was not caught until the sentencing date on January 29th. And apparently the Department of Corrections noted that for it to be a second offense, it had to be a conviction for 750.520B, C, or D, which his previous conviction was not for. So there's a real question as to whether or not it was even properly listed on the information, and then he didn't plead to it. It was not even discussed at the time of the plea because it was going to be dropped, but it was listed on the information. So with all that said and done, I believe the resolution is that what we're going to do is reset this for sentencing, just to clarify all of this, to make it clear that he pled as a CSE second, no contest. We're gonna, the prosecutor, Mr. Gabriel, your proposal was to file an amended information, just removing that notice. So there's not that confusion in the information. And then the judgment will show CSE second degree. The Department of Corrections will update the pre-sentence report, make a recommendation based on that and that alone, and then provide any updates as to what has occurred since then, and we can have a good, clear record of what actually happened. Is that agreeable, Mr. George?
Yes, Your Honor, and I've gone over the same with my client, and he does agree with that.
Is that correct, Mr. Drake?
Yes.
Okay. And Mr. Gabriel, is that what was discussed?
Yes, Your Honor, I've already prepared the amended information if possibly the court and defendant agreed with what I suggested.
Certainly. So, any objection to that, Mr. George?
No, Your Honor.
So the amended information will contain 2 counts of CSE in the second degree. I'm sorry, 3 counts of CSE in the second degree. It'll not list the second or subsequent offenses. It will still list the habitual, but the plea agreement will show that he's pleading to just 1 count, dismiss the rest, and then dismiss file 2023432.
Correct.
All right. So we'll reset this for sentencing on
June 18th.
June 18th at 1 o'clock. And Mr. Drake, they'll come out and they'll take your interview. You don't need to fill out a new packet. I'll write an order indicating that what we're doing here today is just correcting the improper information in the judgment that was entered, and then we'll reset it for sentencing with notice to the victims so that they can appear if they wish to. Agreed?
Good.
Everyone?
Agree.